Swayam Prabha. Digital India. Educated India.
So, welcome back to the 19th lecture. Now, after we have discussed the law of torts and the law of consumer protection, this is another interesting area which is part of our course on this law of torts, consumer protection, motor vehicles, which is motor vehicles. Motor vehicles basically means all vehicles which are operated through motors, but this law principally, to the extent which we will discuss, is largely related to road accidents or road related aspects. Motor Vehicles Act is the principal legislation dealing with all types of license, vehicle related matters, pollution aspects, everything related to motor vehicles in India. However, we are not going to cover the whole legislation or even a large part of it. We are going to only restrict our study to a very limited aspect, which is the liability for motor accident claims. So, that is why the title of this particular lecture, lecture 19, is Compensatory Jurisprudence under Motor Vehicles Act. So, when on road an accident happens and a person die or suffer a personal injury of very serious and grave nature or even not so serious, then he or she has a right to claim compensation. So, that compensatory mechanism and how it will work and its operation has been laid down in a limited about 20 sections between section 142 to section 168 of the Motor Vehicles Act. So, our study is largely limited to these portions. We will discuss in this lecture these 4 important topics: road accident cases in India. So, basically in this we will discuss what types of road accidents are happening, how many road accidents are happening, compare it with some other countries a little bit and see what is the scenario in India. Then there is a very important maxim which excluded law of torts applicability in cases where the person has whether the tortfeasor or the victim has died. So, this was called death discharge tort. So, there are various ways in which torts can be discharged. We will discuss that in I have discussed already in our previous lecture. So, if you recall, one of the dischargements that we said was death, but this is an old common law doctrine which does not operate now. Now, death does not discharge tort, and that is why motor accident cases are there, and we will discuss about the how exception has been made. Then we will discuss the Motor Vehicles Act and especially this liability mechanism, and lastly we will discuss some recent initiatives which have been taken by the central government in order to ensure road safety further and strengthen it so that roads become much more safer for people to travel. Now, anyone, it does not take a rocket science to state that when they are traveling on the road, whether they are walking in the pavement or they are driving their car or their bike or their bicycle or boarding a bus or even goods vehicles, everyone requires some safety on the road. So, we do not step out with the road with, we do not want this kind of a scenario that we step out on the road with this fear that any point of time we may meet accident. And we do not also drive on the road that though we have to be cautious, but we do not drive on the road with this presumption that somebody is going to hit me. But unfortunately, if such an event happen, then what is our protective mechanism? And most importantly, if a driver of a vehicle negligently causes an accident and a compensation is now payable for that person, but the person says, I am a poor fellow, you send me to jail, but I am not in a position to pay the compensation. What will law do? What is the recourse? Right? So, in all this, keeping in mind, the Motor Vehicles Act was enacted. So, Motor Vehicle Act's first primary objective is to ensure safety of the users and the properties etc. surrounding the road networks. Try to ensure as far as possible accidents are avoided, making such conditions and rules and norms. Also, to see in case there is an accident, how the liability mechanism should work, and lastly to see that when it comes to compensation, paying compensation, this should not be a ground that I am not in a position to pay compensation. So, for that the innovative third party insurance mechanism has been included. So, it is now the duty of the insurance company to pay. What the owner's duty of every motor vehicle is to buy a compulsory insurance. So, insurance is thus compulsory because if in case unfortunately you hit or you be hit, you know that the insurance company is there to pay the compensation in case if it is a negligent and a wrongful act causing to that accident. So, now after discussing this broad aspect of Motor Vehicles Act, now let us come to the first topic, which is road accidents in India. Now, India has a fairly big country and it is densely populated, and road network plays what is called the heart line. And India has the second largest network of roads in the world, which is about 63.75 lakh kilometers. And this road transportation carries 87% of India's total passenger traffic and more than 60% of its freights. So, you can see therefore the importance of the roads. We like or we do not like, we cannot avoid road travel. So, 87% of India's total passenger traffic is carried by road network, and 60% of the freight of India is carried by the road network. Nearly 280 billion is being spent on roads under National Infrastructure Pipeline, 18% of the total outlay. So, out of the total outlay of the India's budget, nearly 18% is spent on roads, which is roughly around 28 lakh billion rupees, which is the national infrastructure for the road networks pipeline. Highest ever construction is happening in the national highways between 20 to 21, nearly 37 kilometer per day construction was being made. All this information or data which I have presented before you is from this Invest India, a government initiative, and it is available in the website of that Invest India, and the source of the website is prescribed at the end of the slide. So, if you wish, you can go there and see further. But as I mentioned, India is the second largest road network in the world, having second largest country having road network in the world. When it comes to road accident, India is number 1. There is a body called the National Crime Reporting Bureau, NCRB, and this NCRB prepares a report called Accidental Deaths and Suicides. Now, according to this NCRB's report of accidental deaths and suicides in India in 2021 data, it is presented that during 2021, total 4,03,016 cases of road accidents were reported. Now, this figure comes from the police FIRs. So, what NCRB, the source or the methodology of NCRB for collection of data is asking from the police thanas to provide them the information based on the FIRs reported. So, nearly 4,03,016 cases of road accidents were reported, which rendered to 3,71,884 persons injured and 1,55,622 deaths. As I said, all these information are collected directly from the FIR of the police reports or police records. Nearly 45.5% of the victims of road accidents were riders of two-wheelers, followed by cars, trucks, lorries, buses, accounting like 15.1%, 9.4% and 3% respectively of the road accident deaths. So, therefore, the highest number of people who died on road accident are largely riders of two-wheelers. But followed by that closely are car, trucks and lorries, which is 15.1%, 9.4% and 3%. Majority of the road accidents, that is nearly 59.7%, more than 50%, nearly 60%. Majority of the road accidents were due to overspeeding, accounting 87,050 deaths and 2,28,000 persons injured. So, overspeeding. Now, there is a usual cause linked to the overspeeding, which I will come across my next slide. But alcohol use or use of narcotic substance is often considered as one of the reasons for this menace of overspeeding causing road accident, and which is leading to a huge number of people giving their life or succumbing to very serious injuries. Next category is dangerous or careless driving or overtaking, contributing to nearly 25.7% of road accidents, rendering 42,000 deaths and 91,000 persons injured. Beside, 2.8% of road accidents are due to poor weather condition. So, due to poor weather condition, there are some road accidents, but the number is minuscule. So, the majority of the road accidents in this country happens due to overspeeding or dangerous careless driving or overtaking. 59.7% and 43.3% of road accidents were reported in rural areas and 29% of road accidents were in residential areas. So, therefore, it is not very clear, not very it is not very correct to say that rural areas are safe, because largest number of accidents have happened in rural areas, and the reason is that national highways are present in the rural areas, and in rural areas drivers are more careless, more indulge in overtaking, more indulge in other types of dangerous ways of driving, and hence the accidents are more compared to city areas where the number of accidents are less. And similarly, 29.9, nearly 30% of these accidents are in residential areas. So, even our residential areas are not safe. So, if we feel that if I am living in a peaceful residential area, I am usually safe from road accident, it is not that. Even residential areas, there is nearly 30% of the accidents happening. Now, Supreme Court in 2016 had a PIL to discuss and decide about how do you curb the menace of road accident and how do you deal this problem. So, there are some important findings based on data provided by this judgment of State of Tamil Nadu versus K. Balu 2016, and also the very important decision made by Justice Chandrachud, leading judgment, the current Chief Justice of India. At that time he was not the Chief Justice of India, which led to complete ban and prohibition of sale of alcohol within 500 meters of a national highway. That was a very important decision, and in this case there were some very important facts and figures which were quoted by the judgment, in the judgment of Justice Chandrachud. The first figure that he cited said during 2015, of course, I have given in my earlier two slides data which are much more recent and relevant, but in this case this judgment is giving the information based on the data of 15 and 16, because the judgment was written in 2016, but you can, when you study this data and compare it with the 2021 data which I have provided in my from the NCRB report, you see that there has not been an alarming change in the circumstances, although there has been a lot of efforts that have been taken by the state, as Supreme Court had initiated the state or encouraged the state to take more stringent action to control and to reduce the number of deaths caused due to road accident. But it appears that there has not been a very big or very stark difference in the scenario. Now, in 2015, within the category of drivers fault, accidents caused and persons killed due to exceeding lawful speed. So, in my earlier slide, I had said that nearly 59.7%, nearly 16% of 60% of the road accidents are caused due to overspeeding. Similarly, in Justice Chandrachud in 2015 also said that maximum number of cases have been recorded where the accident has caused due to exceeding lawful speed accounted for a high share, 62.2%. So, in 15-16 it was 62.2%, in 21 it has reduced to 59.7%. So, marginal proportion of decrease, but not a major decrease, keeping in mind the actions that have been initiated since that time when this K. Balu's case came. So, a study of the figures between K. Balu to the current will be an interesting way to understand that how this implementation or how the actual ground level changes have occurred due to the enacting more stringent roads rules or more stringent accident control sort of policies and preventive measures. So, among these 62%, 2,40,463 out of 3,86,481 accident cases, and 61% of these accident cases rendered to death, which is 64.633 out of 1,06,021 deaths. So, out of the total number of people who died in road accident, nearly 61%, that is 64,663 people died due to overspeeding or exceeding lawful speed. If we compare this also with the figure, we will see that death caused due to overspeeding is nearly 25.7%, and the death. So, therefore, there is here also not some change in the figure, yes, some substantial change, but still the percentage of figures of death is quite high. Now, Justice Chandrachud in his judgment in State of Tamil Nadu versus K. Balu very clearly held that intake of alcohol and drugs by drivers resulted in 16,298 road accidents, and of these 6,755 were fatalities in 2015. So, whether it is overspeeding or careless driving, nearly 16,298 road accidents and 6,755 deaths were caused due to drivers' fault who were under the influence of alcohol or drugs, and these were mated by testing. So, when after accident they were tested, they found to be driving under the influence of drug or alcohol, and it is around 4.2% of the 6 point. So, nearly 4.2% and 6.4% respectively who were found to be driving under the influence of alcohols or drugs. However, taking into account the total road accident and the total accident killing, the share of intake of alcohol drugs comes to 3.3% and 4.6% of the total deaths. So, among the total deaths caused in road accident in 2015 data, about 4.6% and 3.3% are caused due to people who were under the influence of drug and alcohol, which is not less, which is about roughly 8%. So, therefore, drug and alcohol was found to be one of the very important factors which is leading to road accident. So, that made the Supreme Court to come up with this direction that prohibiting sale of course obviously narcotics is banned. So, there is no question of sale of narcotics, but alcohol is not banned. So, Supreme Court came up with this decision that within 500 meters from the radius of a national highway, there shall not be any sale of alcohol. Of course, sale of alcohol has a great linkage with collection of taxes for the states. So, the states had certain observations, there were certain other objections raised from other quarters. So, some modification had happened over time, but it was a step that was initiated by the Supreme Court in 2015. One of the ways to curb these road accidents or making the road network system or road travel safer. Now, moving further. Now, one of the big challenges in the motor vehicles law has been that how do you fix liability? Because in conventional and traditional common law, there was a maxim which governed or which emerged and ruled for a long period of time, which was called actio personalis motor cum persona. Actio personalis motor cum persona. That means action of personal nature dies with the death of the person. So, in our discussion on dischargement of tort, when we discussed this, that what are the ways tort can be discharged, one we said that this old way of this actio personalis motor cum persona, that is action of personal nature dies with the death of the or discharged with the death of the plaintiff or the defendant. It is personal nature. So, with the death of that person it dies. It does not continue after the death. But this was subsequently found to be very seriously impeding justice in many cases, because with the change of the nature of the economic activities, change of the nature of the social system, many things emerged where this maxim was a serious challenge. For example, accident caused due to in industrial operation. Now, the person who died, his family will suffer unless given some compensation, but the employer will be justified to not pay compensation under this particular rule. In road accident cases, the driver will escape because the person has died. Rather, it is an encouragement that do not keep him alive, but kill him. So, therefore, this cannot exist, right. So, therefore, this particular maxim has given away over time, and it has been replaced or statutorily modified. Now, England, the first modification of this maxim happened in 1855 by a statute called the Legal Representative Suits Act, which stated that for action by representatives of a deceased person, the action against the representative of a deceased person may be allowed. So, when an action has been taken by a deceased person's representatives or against a deceased person's representative, they can be allowed. More important change was introduced in the 1855 Fatal Accident Act. Now, Fatal Accident Act is the predecessor of, it does still exist, but it is the predecessor of all these laws relating to accidents. So, whether motor accident, industrial accident or other types of accident laws, fatal accident law is a very important legislation. So, in 1855 Fatal Accident Law provided that whenever death of a person shall be caused by wrongful act, neglect or default, the party who would have been liable if death had not ensued shall be liable to an action for damages, and such action shall be for the benefit of the wife, husband, parent and children. So, all the representatives of the deceased person who was subject to death or injury here obviously should lead to death, is caused by a wrongful act or neglect or default. Then the Indian Succession Act of 1865 also made a change to this rule statutorily by enacting that all demands whatsoever and all rights or to prosecute or defend any action or special proceedings existing in favor of or against a person at the time of a decease survive to and against his executors or administrator, except cause of action for defamation, assault as defined in Indian Penal Code, or other personal injuries not causing death to the party. So, What this provision said, that all such cases where the deceased have been subjected, his right to prosecute will continue and it will be transferred in favor of his representatives of the deceased to take such all actions against the executors or administrators or whoever is responsible for such wrongful act, except a cause of action for defamation. Now, even for defamation also subsequently this rule has been modified by judicial decision, but when this was introduced earlier at 1865, defamation was excused, assault was excused, and some types of personal injuries not causing death were also excused. But now defamation is no more excused. The reason defamation was excused is a reputation is for life. So, if a person is not alive, then even if his reputation is affected, it does not matter. But in the Priyambada Birla case, the Supreme Court had to examine this case whether reputation survives of some persons beyond his death. So, for example, if somebody now disreputes Jawaharlal Nehru, it would not be fair because Jawaharlal Nehru has earned his reputation and thus reputation needs to be there. Of course, there are some privileges that are allowed because he was a political person, but other than that his personal level disreputation will be an act which not be allowed. Now, Motor Accident Act is also cases or motor accident legislations have also enacted a change or modification to this rule of actionio personalis motor personam causa. It says that in motor accident cases legal representatives can continue for claiming of compensation even with the death of the victim, because when the victim dies the family does need more support. So, therefore, if you excuse them it would be a big injustice, right. And it was the Motor Vehicles Act of 1939 in India which was first introduced to govern laws and regulations relating to motor vehicles, which was parallel to the English Road Traffic Act of 1930, and this act was applicable for a long period of time from 39 to 88, and 88 due to changes in the social system, technology, needs, increasing population, increase of motor vehicles, road traffic rules, it was found that this 39 Act was not adequate or not effective, and there were also some implementation hardship of certain provisions. So, it was replaced by the Motor Vehicles Act of 1988 which is still governing us, and in section 158 of this Motor Vehicles Act of 1988, it is clearly stated that if a person has to drive, at the time when he is driving in a public place, he shall be at any point of time carrying this following information or documents which is issued by the Department of Road Transport, and a police person can any point of time ask to produce these documents in original. So, what are these documents that a person has to carry when he is driving? First, a certificate of insurance, that the vehicle is insured against third party liability as required under the Motor Vehicles Act. He has to carry a certificate of insurance. Second, he has to carry a certificate of registration. So, there is a need for him to produce that his vehicle is a registered vehicle, his vehicle has performed all the compliance required under the Motor Vehicles Act, his vehicle is fit and he has paid all the necessary taxes including the road tax and other government tax and duties. So, the certificate of registration. Third, that person requires to produce his driving license. The driving license is a proof of that fact that the person who is behind the wheel has competence to drive as registered and certified by the government. And obviously, there are conditions as to who is eligible to apply for driving license. So, any person must be 18 years and above to be eligible to secure a driving license. So, certificate of insurance, registration, driving license, and the fourth is in cases of transport vehicle, certificate of fitness transferred to referred in section 56, the permit relating to use of the vehicle also to be produced. In case of vehicles which are listed as domestic or for personal use, then in that case you only require to produce these three: In addition, you have to produce also the pollution certificate, that is the vehicle is under the prescribed norms of vehicular pollution. But if it is a transport vehicle, that is a vehicle which is largely a goods carrier or a vehicle which is used for the purpose of transport of people or goods, then it has to produce an additional document which is a certificate of fitness, which is referred in section 56 of the Act, and the permit relating to use of the vehicle, and obviously he has to also produce the pollution certificate. If you are not having these documents with you or in the public place, the police can always seize the vehicle, police can arrest you. Police has a lot of powers in order to deal with these matters. Now, as I said, insurance is one of the unique features of the Motor Vehicles Act. Now, what insurance attempts to ensure? Now, for example, X has met an accident. Now, Y has died. Y is a poor person who is the sole breadwinner of his family, and therefore, Y has filed a case for compensation. Y's representative, the wife. Now, there is a provision under the Indian Penal Code where a person who has been engaged in rash and negligent driving leading to death of a person can be also punished for penal offences. Now, if that person is punished for penal offences, it will not help the X who is the deceased person in the accident, because X's family needs money to support their family. So, therefore, it cannot be just penal provisions are enough. So, compensatory provisions are required in certain types of cases in order to meet the need of the family, the economic need, the financial need, and all the living needs of the family. Now, if X says that I am ready to go to jail, but I do not have any money to pay compensation, then it will lead to the same problem. The family members of the deceased will not get anything. So, to ensure that this kind of situation does not arise, what law has stipulated is a model insurance format. Now, what you have to do is that you have to buy a insurance at the time of purchasing a vehicle. So, every owner of a motor vehicle should have a insurance, and every year he has to pay a premium. By paying the premium, you ensure that in case if you meet an accident, whether you are injured, your vehicle is injured, damaged, or you hit someone, injure somebody's vehicle, kill someone, or some damage causing to the third party property, then the third party is also insured and the insurance company will pay the compensation. So, it is not that you need to pay the compensation, the insurance company will pay the compensation. So, this whole scheme is laid down in the Act. In section 146 of the Motor Vehicles Act, it is not choice, voluntary or optional, but it is mandatory. So, section 146 of the Motor Vehicles Act says it is mandatory for all vehicles to be insured against liability to third parties, and that is why it is very important. TPA, third party, insured against liability to third parties, and the payment of victim compensation is linked to such third party insurance. So, section 46 clearly lays down the scheme and the objective of the insurance system. Section 147 of the Motor Vehicles Act requires policies and limits of liability. So, 47 talks about what are the policy requirements, how much you have to pay, what is the minimum statutory mandatory conditions. Now, these days if you go to buy a motor insurance, you will be given a form where there are many things that are included, that your vehicle will be insured against this. Now, there are many things which are like bumper to bumper insurance, these, that, which are not all statutory requirements, right. They are good, in case you meet some damage, they will help your financial support for that. But there are some parts which are conditioned, which are required to be statutorily, mandatorily included. So, there you have no option. The insurance company has to include those and you have to pay for that. Now, in terms of the over the mandatory, there are certain which insurance company will include and the customers will have a choice to take or not to take. But the mandatory requirements are laid down in the section 147, and clearly also it is laid down how and what kinds of limits of liabilities can be placed by the insurance company. The insurance companies cannot go beyond that also. And section 149 of the Motor Vehicles Act establishes a duty on the insurer to satisfy the judgment awards against the person insured in respect of the third party risk. So, as I was mentioning that when there is a third party risk and when there is a accident happens, now the procedure usually followed is that after the accident has been reported, all the investigation is conducted, and if there is a death of the person, then all the informations are collected and accordingly they are placed before the Motor Accident Claims Tribunal. Now, in the Motor Accident Claims Tribunal, the matter is litigated. Now, some limited defences are allowed. Now, that defences may be, say for example, defence of contributory negligence may allow to defreeze the amount of the compensation to be paid, etc. But after all this, once the award has been made and the judgment of the decision of the Motor Vehicle Accident Claims Tribunal has been made, then it is the duty of the insurance company to the persons insured in respect of the third party risk to pay the compensation directly to that person. So, there is no question of the person who has caused the accident, whether he has the money, he does not have the money, whether he wants to pay, not wants to pay, all these appeal, this, that, but it is the insurance company who will have to pay the judgment awards, and that is why insurance companies are also made in the proceedings of the Motor Accident Claims Tribunal, and the insurance company are thereafter they participating in the process. Now, a new system has also started in this regard in order to expedite the resolution, because Motor Accident Tribunal cases required a long time, and there have been also many reforms that have been introduced in the claims tribunal, because ultimately one has to understand that the moment a person accidentally die or is seriously injured or become permanently disabled, it is a matter of great stress not only for the person but for the family. And in cases where the person is a sole bread earner, almost the family is stranded into a deep financial problem, because there are so many things that are associated to the earning of that person, and at that point of time there are medical costs, there are regular costs. So, at that point of time, if the money is not immediately provided, it becomes very difficult. So, that is the reason why the motor accident cases are now largely referred to Lok Adalat. Lok Adalats are a form of alternative dispute resolution, and alternative dispute resolution forums are usually argued to be expeditious, speedy, less costly, and in motor vehicles claims cases in Lok Adalat, parties are negotiating in assistance of the Lok Adalat members to come to a reasonable compensation, and it is discharged also within a short span of time. So, that is a new procedure which has been also followed and quite successful in India, but otherwise it is the Motor Accident Claim Tribunal which has to decide the matter. Now, coming to the liability regime laid down by the Motor Vehicles Act. Now, Motor Vehicles Act talks about two types of liabilities largely, and there is a third type which is called the hit and run. So, the first type of liability is called the no fault liability, and the second type of liability is called the fault liability. Now, we have already seen in our discussions in law of torts what is the distinction between fault and no fault. No fault means it is immaterial of the fact that whether there was any wrong on your part or no wrong on your part, you have to pay compensation. The case of strict liability or absolute liability is a case of no fault liability. But majority of the tort litigation stands on the ground of what we call fault liability. That is, there is a fault on the part of the defendant, and that is why the justifications are also very important, because if the defendant can plead that his act may cause loss and damage to the plaintiff, but it was justified act, then it will not be constituting as a wrongful act, and hence he is exonerated or partially exonerated, right. Now, that is whether there is a fault. So, that is called the fault liability. So, the large part of tort litigation happens on fault liability. There are limited number of cases where no fault liability is applied, and in India we do not have no fault liability, we have extended it to what we call absolute liability, and the distinction between absolute and no fault liability I hope you remember, but the fault and the no fault liability is this. Now, in Motor Vehicles Act also we have introduced the no fault liability as well as the fault liability. And the third is the hit and run liability. I will discuss all this in details, I am just telling you. So, fault liability, no fault liability, fault liability, and liability in hit and run cases, right. Now, let us discuss each of them individually. First, no fault liability. Now, it is immaterial whether there was any fault on the part of the other side, or there was no fault on the part of the other side. It is totally immaterial. What is required is, it is a matter of policy that in this case compensation will be paid. Now, Motor Vehicles Act prescribes two particular scenarios where no fault liability is applicable. The first is in section 140 of the Act, which says payment of a fixed sum of rupees 50,000 in case of death and rupees 25,000 in case of permanent disablement as a compensation to the accident victims without any requirement to prove that the accident occurred due to neglect or default of the owner of the driver. So, section 140 clearly states that there is no burden on the plaintiff in the case of seeking compensation under 140 to show that there an accident which was occurred due to neglect or default of the owner of the driver. In this case, if an accident has happened and it is an accident which is falling within the category of the Motor Vehicles Act, then section 140 will apply, and if the victim has died, then his heirs and representatives will be entitled to rupees 50,000, and it is a fixed sum. There is no question of more or less. According to 140, it is a fixed sum of 50,000 rupees in case of death, and in case of permanent disablement, rupees 25,000. The second provision where liability under no fault regime is discussed in Motor Vehicles Act is section 163A. Now, 163A was inserted in the Act through the 1993 amendment, and the objective was also to pay compensation for death and permanent liability in limited number of cases where there is no fault. So, no fault is required to be established or discussed. So, there are two provisions, but the question is, are these two provisions same or they apply to different scenarios or different types of situations. Now, actually if we look at the provisions of these two sections, we will see that there is a distinction between the application of the two sections. Now, what are the distinctions? The first distinction between 140 and 163A is that 140 provides for payment of a fixed sum of interim relief. So, 140 is more or less like an interim relief. Now, what is interim relief? Now, as I said that moment an accident has happened, you need the money most at that point of time. Now, after 10 years you get a good amount of money, it will still not be that valuable than even a small financial help that you get at that moment. So, therefore, when a accident happens which is falling within the category of motor vehicles accident under the Act, section 143 provides for a fixed sum of interim relief which can be immediately granted based on whether death or permanent disablement, the amount is 50,000 and 25,000 respectively. What 163A provides is that payment based on a structured formula and is a nature of final remedy. So, 163A is also a no fault, but 163A is not an interim relief. 163A is a final relief, and the calculation of what compensation is due under 163A is also based on a structured formula, which we will discuss in our next lecture as to how to grant, how to calculate compensation which is due and reasonable in motor accident cases. So, there are formulas that are applicable, and based on that formula in 163A, a final sum is granted. So, 140 being an interim nature, 163A is a final. Now, remedy under 143A is available to any person. Now, 140 remedy can be availed by anyone, it is an interim relief. But 163A caters to only specified class of person having income less than 40,000. So, the objective of 163A is if you are a poor person having income less than 40,000, then you are usually not required unless you willingly want. You are usually not required by the law to go and undertake the litigation to get your compensation. If an accident has happened and you are having an annual income less than 40,000, you can approach the motor vehicles tribunal under 163A and say that please pay me one time compensation, and it should be a no fault, that is, I do not need to establish that the other side has a negligence or etc., etc. And the third difference is that a person can make either a claim under 140 or 163A. That means, however, two no fault liability claims cannot be made. So, a person who wants to make a claim under 140 is entitled to make a claim under fault liability, and if his claim under fault liability is fulfilled, then the amount he has got as interim relief as part of 140 will be deducted from that judgment award. But in 163A, if you have made an application, then after that you cannot apply for the fault liability based relief, because this is a final, right. But it is also not that you can ask for interim relief for no fault basis under 140, and then you can again ask for 163A for a no fault relief for final. That is not possible. So, relief under 143 and 163A are limited and they cannot be availed together, right. Now, coming to the fault liability. Now, section 166 of the Motor Vehicles Act establishes the fault liability. Now, what section 166 says that Motor Vehicles Act, a person can claim compensation for death or bodily injury or damage to property under it. In such cases, the claims tribunal can award any compensation that is deemed just in the facts and circumstances of the case. While doing so, the claim tribunal will assess whether there was a negligence on the part of the owner or the driver of the vehicle. So, simply what 166 means that if there is a negligence on the owner or the driver of the vehicle, then a claims tribunal will pass such compensation. In absence of negligence, if it is found that it was not the fault or negligence, then the claims tribunal can see what alternative mechanisms are existing, but the fault is to be established under 166, then 166 compensation is deemed and any compensation of any amount can be paid. So, if a person say is a poor person, he needs immediately money, what he can do is that he can apply for relief under 140 and then continue to litigate under 166, right, because 166 relief requires adjudication, so it will be time consuming. And Motor Accident Claim Tribunal established under 165 is an exclusive forum by the state governments for the disposition of claims of compensation arising out of motor accident cases. So, any compensation mechanism is to be only decided by the Motor Accident Claims Tribunal. Now, the third category of liability is called the hit and run cases. Now, very name suggests hit and run means you have committed the accident and then you have run away from the scene and you are not available. So, that means in the application of the earlier sections 140, 163A, 166, there is a identified offender or identified person. But when there is no identified person, then it is called as hit and run. So, where the identity of the motor vehicle cannot be ascertained in spite of reasonable efforts, it falls within the category of hit and run cases, and this has been defined or provided under 161 of the Motor Vehicles Act, and it says that payment of compensation in cases of death or grievous hurt arising from hit and run cases. Although there is no clear definition that what is hit and run, it means more or less, as has been held by many authorities, that where the identity of the motor vehicles cannot be ascertained in spite of reasonable effort. Now, what is the nature of the compensation to be paid in case of hit and run? In cases claimant is entitled to 25,000 in case of death and 12,500 in case of grievous hurt. An application seeking compensation is to be made to the concerned subdivisional officer or tehsildar in accordance with the provision of the Solatium scheme of 1989. So, every state has a Solatium scheme or what is called the compensatory scheme of the state, and this Solatium scheme, the operational person is the divisional officer or the tehsildar, subdivisional officer or the tehsildar, and if there is a hit and run case, then a compensation can be granted up to tune of 25,000 for death and 12,500 for grievous hurt. However, this amount has been increased in subsequent state amendments or subsequent state related matters, but it has been not very much. So, it is still a very small scheme or small amount that can be recovered, and this recovery can be made under the Solatium scheme of 1989. So, as per Motor Vehicles Act, there is no provision for hit and run case compensation. The reason is that there is no identified person, but this very much clearly establishes that this is an encouragement for people to cause accident and run away, because if they are caught or if they go and surrender, then there is a possibility that they will be sued. They have to pay greater amount of compensation, although they do not need to pay, the insurance company will pay. In many cases they do not even buy insurance, and all these lead to the figures that we have seen at the beginning of why India is the highest number of road accident cases happening. So, therefore, to deal with this, as I said, legislative initiatives have been introduced to make things more stringent, make things more tough, make things more complex, not complex, make things more comprehensive, and that is why the Bharatiya Nyaya Sanhita 2023. Now, you must have come across there. In 2023, the Government of India has introduced 3 new criminal law amendment bills. These are to replace the Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act. The law which will replace the Indian Penal Code is called the Bharatiya Nyaya Sanhita 2023. Now, in Bharatiya Nyaya Sanhita 2023, in section 1062, a provision has been introduced which can make the motor accident hit and run cases compensatory mechanism and the legal framework much more stringent, much more effective, much more comprehensive. What does this provision states? This provision states that whoever causes death of any person by rash or negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to police officer or magistrate soon after the incident shall be punished with an imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. Now, this caused a huge uproar, because at present there is an encouragement, because the law is absolutely blank, and if you hit someone and then run away from the scene, and if you are not found, then you are completely safeguarded. But this law says that if you are unfortunately found, then you have a very stringent punishment, because it imposes a duty now, a positive duty, that if you hit someone, it is your duty to report to the police station or the nearest magistrate and ensure that the person is attended. The humanitarian aspect of saving the person is there. If there, then that is served. Now, of course, the moment this act was introduced, this provision was introduced, it led to severe strike among the motorist and truck association, bus association. So immediately the applicable the bringing effect of this law has been paused by the government. But this is a great step towards the government honestly saying for the purpose of securing a better safety of road. In addition, the Motor Vehicles Amendment Act of 2019 has introduced several measures. For example, stricter penalties. So penalties have now increased for not carrying driving license, for over speeding, for jumping red light, for not wearing seat belt, for drunk driving. Very stricter penalties have been introduced. Electronic monitoring and enforcement has become important aspect. So technology enabled monitoring has been there. A good Samaritan protection scheme has been introduced, wherein to encourage people to come forward to assist accident victims, because earlier there was a fear that if I assist an accident victim, the police may harass me, I may get arrested, etc., etc. So now the Good Samaritan scheme suggests that in case of a medical emergency or non-medical assistance, people should come up and they should support, and the government is encouraging them. And the last one is a Motor Vehicle Accident Fund, an act which is established by the Motor Vehicle Accident to pay compulsory insurance coverage to all road users in India. So for all road users, a compulsory insurance scheme is to be brought in place, and the amount to be secured is from motor accident vehicle funds, and this is again collected from the moment a vehicle is to be registered. A small cess or petrol purchase, small cess, or part of when you pay for this what you call it, when you are driving from one place to another, you pay road tax, toll tax. So in toll tax, one cess can be added, which can go together to contribute to this motor accident fund. So these are some important steps. So this first discussion on the Motor Vehicles Act, which is the liability mechanism and the compensatory model. Now in the next lecture, which is the last lecture of this course, we will discuss about the calculation of the compensation and how this amount has been granted and what is the models that have been evolved by the Supreme Court over time. So I hope you have enjoyed this lecture. Looking forward to see you in my last lecture. Thank you very much.